All right. Court of Appeal 146, the state of Florida is now in session. John K. Sargent, Justice tonight. All persons having business before the court draw near and give us and continue to be heard. And God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. I'm here for three cases today. One of them is set for 9:30, and then we will pick up with the others at 10:30. I want to remind everybody here today to please silence your cell phones and turn them off. And we will. First, I want to recognize that visiting judge Lambert from the 5th DCA, and really appreciate you being with us and helping us get through this shortage of judges that we've been having due to Judge Cohen's retirement and Judge Sasso's elevation. And then also joining us today is Judge Nardella. It's great to see you again, Judge Nardella. Our first case this morning is Becky Kersey, individual and as trustee of the Mary Jo C. Abraham Living Trust versus Kenneth J. Abraham. We have Ms. Hilliard. Okay. And Mr. Mashburn. Mr. Mashburn. All right. And then, okay. And then on behalf of Mr. Abraham, we have
Olivia Share.
okay. And you are? Okay. All right, well, you'll each have 20 minutes per side. The appellant will have opportunity to reserve rebuttal time and be recognized.
Good morning, Your Honor. May it please the court. As I stated, my name is Eric Mashburn. I represent the appellant in this case. My co-counsel, Claire Hilliard, is here as well. I'd like to reserve 5 minutes of my time for rebuttal.
Okay.
Your Honor, this case involves the determination of the respective rights of beneficiaries and a trustee with regard to property that was held in the name of the trust. My position is that the beneficiaries have rights in that property, and under the terms of the trust in question here, that those rights included a right of possession. The underlying facts of this case is that the party's mother.
We've all reviewed the facts.
All right.
We'll get to your argument. If you want to start by just identifying where your client was at the beginning of this. With regard to, it appears she always intended or desired to live there. Why did she not just go ahead and distribute the property?
Well, Your Honor, I personally was not involved in the case at that time as her attorney, so I do not know the all the details of that. But what her attorney, Mr. Pilcher, said at trial was that from the beginning, she wanted to buy out her brother's interest or to acquire his interest as part of her distribution of the assets in the trust.
So she didn't distribute the property because she was hopeful that the brother and her would have some reckoning and come up with a price and she would buy him out.
Right, that they were, I think the record reflects that they were working on that pretty diligently. The big impediment to reaching any resolution is that the brother, as he testified in trial, thought the property was worth $1 million or more.
And he had no appraisal that could show anything close to that.
And the appraisals that were done were, I think the first one was $460,000, substantially less. They even made an attempt at a point to put it up for sale for the $1 million. They did a homemade sign that they put on the property and had his phone number as the contact.
That's not really marketing the property. Then.
No. So, but I mean, there's no doubt that Ms. Kersey wanted to acquire the property. She didn't want to sell it. And she, as well as her brother, did not want to be co-owners of the property. They testified to that. So they were attempting to work something out. And it seems to me that based on their actions, they basically acquiesced in letting the property, the title to the property, stay in the trust. While they carried on with their negotiations and their efforts to resolve it. Now,
So your client felt everything was going well, but then all of a sudden the brother just sued and it wasn't going well.
no, he sued after she went into possession,
Right,
some 15 months after the mother had died.
correct. But
Correct.
at some point, she takes over. He sues. Why did she not at this point distribute the property? Even though, I mean, I understand, he's saying, I don't want 1/3.
Well,
But
Your Honor, that.
she's wearing two hats. She's a fiduciary, as a trustee, and she's a beneficiary.
Yes. And I've wondered that myself. If I were the attorney at the time, that's what I would have told her to have done, because at the point that the brother was complaining or stating that she should have paid rent, if she had clear fee simple title, there'd be no question that she would have a right to possession, and there'd be no issue of any rent owed to the trust or her breaching any duty as a trustee. But that was not done for whatever the reasons were. But I want to bring to the court's attention that issue, I don't think her failure to distribute the trust can be a grounds to sustain the trial court's judgment, because the trial court specifically found that that claim, the failure to distribute the property, had been released by the partial settlement agreement that the parties entered into. So even though ironically, that if the property had been distributed either by her or by the successor trustee who did not distribute it as well, Mr. Finkbeiner, then we wouldn't be here today. Because there'd be absolutely no basis for the trust to have any claim for rent for her occupancy. So
Let's address that for a second, and I hate to skip all over. You had 6 or 7 different arguments, but towards the end, one of your arguments is that she asked for the property, it wasn't distributed. Is it your position then that from the point in time that she's no longer trustee, she shouldn't have to pay rent?
well, that's based on the damages.
Correct.
So
Because that's all they claim. They're claiming it based on the breach of the fiduciary duty.
Right, the only claim pled was for breach of fiduciary duty. The trial court's judgment was based on a finding of breach of fiduciary duty, nothing else. The breaches were that she failed to pay rent to her, or collect rent. She failed to pay rent as the beneficiary to herself as trustee, and that constituted also a self-dealing. So
under
the
your,
damages were rent on a monthly basis for her failure to.
so your position from the time she moved in, then there was a testimony about a 3-month reasonableness period that she would have been getting it ready anyway. So that's from the time she moved in, which somewhere February.
She moved in September 2018.
Okay, I had October 18. Okay.
Well,
So
thereabout.
So she was started paying rent, say in October 2018.
Well, I think that's the 3 months or something. The judge started it after the
Okay.
3 months.
So
I think.
your position is that it would only go then until the point in time where she resigned.
February
As trustee.
18th, 2020, because the damages were the rent. Okay, so my position is, for breach of fiduciary duty. So my position is that she cannot be guilty of a breach of fiduciary duty when she's no longer the fiduciary. And so damages that first accrue after she no longer was the beneficiary, the trustee, cannot be ascribed to her. And that the rent here she didn't enter into some long-term lease with herself while she was trustee. It, I think, accrued on a daily basis, because on each and every day, she could have either paid rent to the trust or she could have vacated, in which event there'd be no further damages.
So let me understand, then upon the time that there was a successor trustee, any rent that your client did not pay after there was a successor trustee should not be damages because she did not breach her fiduciary duty because she was no longer fiduciary. So at a minimum, any 3750 from was it February 2020?
February 18th, I believe. the date.
Any of those damages awarded for breach of fiduciary duty, which in essence is the rent that should have been paid, the reasonable rent that was testified about, that should be deleted from the judgment.
Right, if the rent judgment is to be sustained by this court, then that's my secondary argument that the amount of damages need to be reduced because there's not a factual basis for them based on the trial court's decision ruling that it was she
So
was
in
guilty of a
essence,
breach of.
The successor trustee then breached his duty by not trying to, well,
Well,
all right.
I'll
paraphrase. I know you don't like any part of that. But in the
Well-
context of where we are right now, if the damages that were awarded because of breach of fiduciary duty was not getting the rent, it was the successor trustee's obligation at that point to say, you know
Right.
what? You basically need to be paying rent, ma'am. And and by not pursuing that, then both of them have been damaged by the successor trust, where the trust has been damaged by the successor trustee not seeking the money from your client.
Right, I'm not
That would be a
contending
yes-
that
would be a
she's
yes for you, that would be helpful for you, I would think, but.
right. I'm contending that based on my primary argument that she had a right to possession as beneficiary, then she doesn't owe rent to anybody for anything. For any period
If she
of
was a
time.
co-owner, but the trust was the owner, so the trust had the obligation of both of them to maximize the estate. And it didn't do that, i.e. the trustee didn't do that by not collecting or charging rent that should have been. In other words, if this was that guy sitting out there renting the property, that he would probably have to pay rent, and the trustee should be charging rent. And both of your clients would, respective clients would say, how come that guy's not paying rent?
Well, yes, if it was a third party occupying the property,
But the trustee is a separate entity and owes an obligation to the beneficiaries to collect assets.
well, but
Isn't it?
that's what exactly the position that the trial judge adopted and exactly the position that I disagree with.
Well, what's illogical about that? I mean,
Well-
other than your client is a beneficiary and you could have avoided all of this by simply deeding the property to the two of them the day after she became the trustee. And then they would have their own internal fight as co-owners of property, but it wouldn't be a trust matter.
Well, that's true, but if she's being held liable because she didn't do that, then that conflicts with the judge's determination that that claim was released by the settlement agreement and has not been appealed. So that is not, I don't believe, can be a ground to justify the trial court's decision. The trial court's decision has to be justified, as the trial court did, on the single fact that title to the property was held in the name of the trust. So in my brief, I tried to cite or cited numerous authorities for the proposition that a trust is not a separate entity in the nature like a corporation is, that it is a relationship between the person who creates the trust and funds it with their property, the grantor, and a trustee who is given duties and responsibilities with regard to the property that was put in the trust for the benefit of the beneficiaries.
But counsel, in this case, the trust is a separate entity because it became irrevocable, correct?
No, well, it's separate in some respects, but what we're talking about here is the relationship, the respective rights between the trust and a beneficiary with regard to the trust property. We're not talking about third parties. We're not talking about.
Well, an irrevocable trust has their own tax ID number. It comes with the trustee's responsibility to file a tax return.
Right,
It's
in some
pass-through
respects,
entity.
it is considered a separate entity. But what I'm focusing on is the relationship and the respective rights in the trust property between the trustee and the beneficiary.
Okay, so when you talk about active versus passive, are you looking at the single asset being the Boggy Creek property? Or are you looking at the trust agreement as a whole as being an active or passive trust?
Well, I think that, I don't think I'm,
Or what should we look at? How would you frame this for us?
all right, here's how I would frame it, is that the trust by its very language is crystal clear that upon the mother's death is promptly thereafter, the property, well, the Boggy Creek property, that's what we're talking about here, be distributed to her two children, 2/3, 1/3, and I quote the trust, outright free of trust.
Correct.
Okay, so the only, so the trust doesn't provide any further duties or purposes with regard to the Boggy Creek property, at least. That's all we're talking about under the terms of the trust. So the trust was merely holding the title until such time as it was appropriate to distribute it to the beneficiaries.
Well, counsel, what would you do with the fact that Article 6D4 on page 10 of the trust agreement provides a tail on interest? And this is my question to you. If Mr. Abraham had died before he had received his interest in the Boggy Creek Road property, who receives his interest, his probate estate or his issue?
If he survived his mother as he did and then subsequently died, then his estate would receive his interest because it was vested at the time of his mother's death.
Is that in contravention of the grantor's intent that it passed to his issue?
No, because that is, if he predeceases his mother,
Right.
then it would be passed to his issue. So, but he didn't. So those aren't the facts here. He survived his mother. So at the moment of her death, the identity of the persons who were entitled to receive this property were clear. And so, you know, some of the things I've cited, they say if a trust is passive or practically passive, in other words, that there's really nothing but ministerial duties for the trustee to do with regard to the property.
But that goes only to the Boggy Creek property. Because the
No.
other is clearly active. I mean,
Well, I'm not-
Or whatever the other properties and the other things that were in the trust required much more. There was management, there was tenants, there was other things. At a minimum, you could only be talking about the Boggy Creek property.
Well, I'm not saying that the Abraham Trust was at the time of the mother's death a passive trust. I believe that there were duties and responsibilities there. I'm saying that either at some time after the mother's death, certainly by 15 months after her death, because the language says that the property should be distributed after the payment of debts and taxes. Okay, so theoretically, it would be possible that the Boggy Creek property, even though it was homestead, might be needed to be sold to administer for administration purposes. But that wasn't the case, didn't happen, wasn't argued as grounds here.
You're at your 5.
Okay, so, I'm up, all right.
Yeah, I mean, you can continue. if you
Well,
want.
I'll just take a little less time. I wanted to say that I think that, you know, it became effectively passive at a point, certainly by the time she took possession, such that all the interest that the trust had at that point was bare legal title, and equitable beneficial interest in that property was in the beneficiary, because that's what the mother wanted. That's what was her intent. She
But I
said,
think
give
we
the
all-
property to my children.
We all see that that was the intent, but it wasn't followed and it wasn't followed and it wasn't followed and went into that. You know, to the point that they had to have a settlement agreement. And now you're arguing that from day one, she should have had.
Well, I mean, court has to keep clear Ms. Kersey's rights as a beneficiary versus her obligations as a trustee. I do not see how whether she breached her duty as trustee can diminish her rights as beneficiary. As beneficiary, she was entitled to fee simple title to that property upon distribution. And if that was delayed because the property was continued to be held in the trust, well, then should not diminish her rights. She should be treated as if she still had those rights.
Why shouldn't she have been held responsible, though, wearing her hat as a beneficiary to say, I'm sorry, we're at a deadlock. Somebody needs to value this property so it can be distributed.
Well, there's no doubt that the administration of the trust could have been handled in a much better way. But what I'm saying is that the trial court based its decision on the mere fact that title was held in the name of the trust. My defense is that she held equitable beneficial interest in that property that included the right to possession, because that's what the trust conferred on her. How can you implement the mother's intent to distribute that property outright free of trust without granting Ms. Kersey as beneficiary a right to possession, which is what she would have had if the property had been distributed? So we have a principle of law that what I forget the Latin term for it, but what should be done will be deemed to have been done. So as beneficiary, she shouldn't be punished because the trustee, whether it was her or someone else, didn't follow the dictates of the trust. She should be afforded the same rights as if the trustee had done what the trust required. In which event, she would have had fee simple title, she would have had a right to possession, she would have not owed rent to the trust.
You have about 3 minutes remaining. Recognize.
Good morning, may it please the court. I'm Olivia Scher here with Nelson Mullins on behalf of the appellee Kenneth J. Abraham. Hearing these arguments, I really want to get down to the central issue of this appeal, which is what Ms. Kersey's ownership interest in the property was at the grantor's death. Ms. Kersey's appeal is based on the fact that she had the right to possess the property because she believes that she had fee simple ownership as a tenant in common with Abraham under the trust. However, this court should affirm the lower court's finding that because the property was titled in trust, the beneficiaries only had a beneficial interest of the property until the property was distributed. If this court agrees that the beneficiaries only had a beneficial interest in the property until it was distributed, then the rest of Ms. Kersey's appeal arguments fail because they're all based on her right to possess the property as a tenant in common. Now, Ms. Kersey relies on the statute of uses and claims that the trust was passive and so it conveyed title to her, or excuse me, conveyed fee simple ownership to her. First, she did not rely on this doctrine in the underlying proceeding, and to preserve an argument for appeal, a party needs to present that specific argument to the trial court. If they don't, it's waived. It's our position that she's waived this argument. However, if the court does consider the argument, it equally fails as a matter of law. Whether the doctrine of the statute of uses applies to give Ms. Kersey fee simple ownership is a trust interpretation question, and it goes to the intent of the settler. And here,
Skip to your damage assessment.
okay, so
Why shouldn't we reverse and say that her rent obligation should end in February of 2020? Because that's when her responsibilities ended.
sure. So I think that there's the law is being misconstrued. A breach of fiduciary duty allegation depends on whether there was a breach of the trustee and whether the damages were a proximate cause of the trustee's breach.
But isn't that proximate cause, isn't that cut off? She has a month-to-month tenancy, correct?
Correct.
Okay, so every month, the new trustee, the successor, the second successor has an opportunity to kick her out. Why doesn't that cut off the chain of causation right there?
Because the Florida law actually tells us. So I have the Flagship Bank versus Reinman case, which is the 5th DCA case. And in that case, the court found that the trustee's liability for a breach of trust includes any profit which would have accrued to the trust estate if there had been no breach. And the award is meant to make the
This wouldn't have been her estate. At that point in time, the baton was passed on to Mr. Pinkbeiner. And it was up to him to do something because your client only sued for the breach. So how can there be a continuing breach beyond the term of her responsibility?
Well, I think that there doesn't need to be a continuing breach. The
Well,
complaint
then where are
was
the
brought.
damages?
The complaint was brought against Ms. Kersey individually and as the trustee. The court found that she breached her fiduciary duty because she was the sole trustee with authorization to enter into leasing agreements, sale agreements, so on
But she
and so
didn't enter
forth.
into a leasing agreement, right? What she did was allow a tenant or herself to stay there month by month by month by its own terms. It ends every month. So isn't there a new breach every month for which the successor trustee, the second successor, is responsible for each month that goes by? Why does she have a continuing responsibility if she has no lease agreement?
Because the only reason that she is in possession of the property was because she breached her fiduciary duty and put herself in that position. And then at that point, the successor trustee due to the ongoing litigation, had not taken any action.
That
However,
was the- oh, go ahead.
Let's do one of my infamous hypotheticals. Well, let's assume Miss Kersey in, after she leaves as a successor trustee, as a trustee, she dies a week later. And her adult child goes, oh, well, I'm gonna go live in, I guess, grandma's house now. I'm gonna go live in grandma's house on Boggy Creek, and she lives there, and Mr. Finkbeiner never takes any action. And there's a suit against Miss Kersey, the suit that your client brought, saying he's breaching, look at all these rent-free days that this property's been going. Why, Mrs. Kersey, who dies in my hypothetical, hopefully she's okay. She dies in my hypothetical, why would she be liable for a breach of fiduciary duty in November of 2020 when the granddaughter is now living in the property and the successor of Mr. Finkbeiner's taking no action?
because the granddaughter didn't have duties to act in the best interest of the beneficiaries and to the trust. And
How is the dead, excuse me, how is the dead person still breaching her fiduciary duty if she's dead?
by failing to pay rent, if her
But she's
estate,
dead, she's not paying rent just because she's dead.
correct, but her,
I mean, well, I guess the panel is struggling with the concept that, yeah, if Miss Kersey was the trustee all the way through and can then pay rent for the 44 months, then yeah, she should have been paying rent, or the trust should have tried to collect rent, and she's breaching her duty to do that. But once she's no longer the trustee, she has no duty to your client about anything. It's the successor trustee, Mr. Finkbeiner,
sure,
obligation, and that's the guy that your client should be aggravated about for the remaining 20-some months with non-payment of rent.
well, really, I believe the question is, did her breach of fiduciary duty proximately cause these damages to the trust? And proximate causation is a fact question, which means that this court can only reverse if there is no substantial evidence in the record to show that her breach of fiduciary duty proximately caused damages to the trust.
But it's the breach of the new trust, Mr. Finkbeiner, and he's the second successor trustee, whatever he is. It's his breach of not taking action, saying, okay, you know what, this has gone on long enough. I'm not related to any of these people. You either need to pay rent or get out, Miss Kersey, and that was the breach by him not doing that. But no, I'm not saying people assume that, but I'm just that seems to be problematic here.
You talked about the evidence in the record, and the evidence of the record is clear. Her fiduciary duty ended when she resigned. So maybe she still owed rent if Mr. Finkbeiner had come in and said, well, look, we want to do this. The testimony is this $37.50 a month. That's for both of those properties. I don't know that there's really evidence that somebody would have paid that on a month-to-month basis, knowing that they would have left, but that wasn't raised. Up until that point, that's what the judge found was the reasonable value. Why should it go beyond the time that she resigned as trustee?
Because she still couldn't live on the property rent free. She still has,
That's under a different legal concept. That's under the concept now as Mr. Finkbeiner that she's living there. He could have kicked her out. He could have kept her. He could have rented it to her for $500 a month and said, I can't find anybody else who's going to move in here. But that starts a fresh set of legal circumstances. Your client only sued for the breach of fiduciary duty that ended on February 2020.
sure, but our client also sued her in her individual capacity, and Florida law says that if a trustee breaches their fiduciary duty, they can be held personally liable for that breach. And also the trustee's liability for a breach of fiduciary duty award is meant to make the injured party, which is here the trust, monetarily whole to the extent possible. And in the flagship case, it was an issue where a trustee had lost the property at a tax sale, and the court was determining how to value the damages.
Yeah, I mean, I don't mean to interrupt, but so your client sees that his sister is no longer the trustee and Mr. Finkbeiner takes over. At that point, your client says, finally, we've got a neutral person involved here. Finkbeiner, look, you need to either get her to start paying rent or get her out as the duty as the trustee to my mother's trust. And And at that point, he takes action or no action. And then if your client is unhappy with the action or inaction taken by Mr. Finkbinder, then the claim is against Finkbinder for breaching his duties for not trying to get money from the sister. Isn't that what this is about?
Well, Ms. Kersey actually did bring that claim in the underlying action. She filed a motion to distribute the property against the successor trustee. However, the lower court found that prior to the adjudication on the merits of the breach of fiduciary duty claim, that that motion was denied. And so now we're here with a set of facts and issues where she.
Counsel, you did sue her in her individual capacity, Ms. Kiersey. I do see that, but
Yes.
wasn't it a single count complaint for breach of fiduciary duty? Wasn't that the only theory under which we're operating?
Sure, but you can, trustee can be held personally liable if she fails to act as a prudent person would and fails to exercise the care and skill of a trustee. And you can be negligently liable on a personal level as a trustee as well. And so here, I think the true determination is whether her taking possession of the property and using her position as the sole trustee to take possession of the property approximately caused damages to the trust as of the date of trial when she still was living on the property rent-free. And the records,
What's your position on that? And they're arguing she was willing to buy it for a reasonable price, but your client couldn't even find anyone to give him an appraisal that he would agree with. Even his own appraisers, he disagreed with them. So he's the reason she wasn't being unreasonable.
well, I think that goes more towards her duty to rent out the property, which isn't at issue in the appeal. The underlying court already found that argument was waived. Here, we're dealing with her duty as the trustee to pay rent to the property or collect rent from her
Or
own
to
personal
dispose of it.
ownership.
She wanted to dispose of it by, he said, I don't want it. I don't want third. I don't want to be part owner with you. He wanted to force a sale. She wanted to buy at a reasonable price. So is there a breach of duty at all? If you've got a willing buyer where her beneficiary had. And your client's the one that's blocking it.
There is a breach of duty because she can't act in her sole personal interest. She has to, as the trustee, act in the interest of all of the beneficiaries.
If they're being reasonable, but he couldn't come up with a price that he's willing. He obviously had some price he was willing to take, but all the appraisers disagreed with him, even his own appraiser. He thought it was worth more than that.
Sure, I still think that goes back to if the court found that a failure to distribute the property was the breach. The breach here was that she, as the sole trustee, took possession of the property and failed to take rent for her possession, and also failed to account for the rents that she did collect from Mrs. Clevenger living on the property. The breach,
Let's talk about that.
Yeah.
Because we're getting towards the end here. You got 7 minutes left, just so you know. The appraiser, I forget his name, says it's worth $37.50 was the rent, right?
correct,
And it was $12.50 is what he thought was the reasonable cost for the small cottage or whatever's on the property, right?
I believe so.
And 2,500, which would leave 2,500 for the main property, but it was only being rented for 700 because that's what the grantor of the trust had originally leased it to the niece for, correct?
Correct.
So if the math, should she be responsible for the difference between the 700 and the 1,250 for every month that the niece was in there? If that's what the grantor had intended, clearly as a reasonable rent.
Well, yes, because she's liable, or a reasonable damage would be the reasonable rent for the entire property for the time that she was possessing the property.
Okay, so your position is that she should have said, well, this is the reasonable amount here, you're only paying 700. You need to start coughing up another 550 a month.
Sure.
Let me ask, let's go off on a different tangent. Your motion for attorney's fees. Do you believe we have the authority to determine entitlement, or is that something that has to be brought solely at the trial court level, or the, I guess, trial court level, or the probate court under 736-1004?
It's my understanding that the trial court has jurisdiction to make that determination.
So. I mean, they make, obviously, they hold the evidentiary hearing saying X number of dollars is a reasonable fee, but. You know, I suspect most trial courts will be hesitant to say, if somebody, in other words, if you never filed a motion here with us, you filed it below. I would think most trial courts would say, hey, unless we get direction from an appellate court, we're not touching anything about awarding attorney fees and probate matters. Do you think the process, you think the statute precludes us for even considering, like in family law cases, we say we grant the motion conditionally on appeal for attorney fees, but remand for the trial court to make findings of need, ability to pay, and the amount. Do you think that's a similar scenario here, that let's assume for the sake of argument, your side prevails and you're seeking fees, that we should simply say, okay, we've determined there's an entitlement to it, and then you guys at the trial court level figure out how that works out under the statute?
Yeah, I think that the court could,
Because your motion is kind of, the motion that was filed on your side, I don't think you're the one, I think Ms. Cole wrote it, but sort of like, we're sending this up. We know that there's some case law that says that you guys can't do it at all, but we just want to cover our bases, which is wise to say, we think you guys should at least determine entitlement, or if you deny it here, please deny it without prejudice, so that the court below understands that, you know, we can still give them just because the appellate court here denied it without prejudice. I mean, I think you cite to a case from the 5th DCA that recently that we determined entitlement. Oh, I did. Don't tell me I wrote it, and I'm sitting there talking about, I don't know what I wrote 2 months ago.
sure. Well, I would say it would follow with that then that this court is authorized to grant
I think
entitlement.
Judge Nardella says we don't have to listen to the 5th all, even though most of us came from the 5th. And she wrote an opinion around and threw the gauntlet down at us.
Counsel,
Rightfully so.
I have the same question for you that I had for Mr. Mashburn. If either beneficiary dies during the course of this litigation, where does their interest in the Boggy Peak property go? Does it belong to their probate estate, or does the trust agreement determine where that interest flows
I
and
think,
why?
sure. So the beneficiary's beneficial interest was in the trust. So if the beneficiary dies, then the trustee would have discretion to,
Discretion?
I guess
On
not
page 8
discretion.
of your brief, you said
Yeah.
the beneficial interest vested immediately upon the grantor's death.
sure,
Okay, so their vested interest, but somehow then the trustee is going to have discretion as to what happens.
yeah, I guess the trustee wouldn't have discretion as to where the who has that beneficial interest. However, what the issue really would be is the fee simple ownership. And upon the grantor's death, I guess it would go and pass through the beneficiary's interest. But the issue here on appeal is whether that beneficiary interest had turned into a fee simple ownership at the grantor's death. And here it had not, because the trust was not passive. And just my last note on that, Ms. Kersey tries to make the argument that the trust was passive just as to the Boggy Creek property, and points at that Article 6D2 sentence that says that the property shall be distributed 2/3 to Ms. Kersey, 1/3 to Abraham outright and create trust. However, in interpreting the settler's intent, you have to look at the entire trust and all of the provisions of the trust. And if you just take a step back and look at Article D, it says that it's subject to paragraph A of Article 6. And what does paragraph A tells us? It tells us that the trustee had discretions as to the distribution of that property. As to the type, he could just distribute it in cash, in kind, or both. As to the timing of the distribution, the propriety of the distribution, and the amount of the distribution.
Council,
And-
should we look at powers and duties as this is these corresponding elements? For instance, if the trust agreement gives the trustee the power to do something, do they have the corresponding duty to do it? For instance, let's talk about the property being insured. They have the power to insure the property. If the property burns down uninsured, do they have a duty for which they could be liable for not doing that? Is that how we should read the trust agreement when we read the power section?
I think that it would be a determination on the circumstances of whether a trustee had the power to do something and didn't do it was actually a breach. But here, the active duties of how to distribute the property is what makes the trust not passive. And so long as it's not passive, then the property was held in the trust with title to the property with only a beneficial interest to the beneficiaries until that trust property was distributed to them. And if she doesn't have a fee simple ownership, then she has no right to possess the property. And then all of her other arguments based on her right to possess the property as a tenant in common equally fail.
And let me ask, the money from the $25,900, why is that being distributed 50-50 as opposed to 2/3, 1/3?
Sure, that's because in Article D3 of the trust, it is unambiguous and it states that the income of the trust is to be split by the beneficiaries 50-50.
But it says the rest and the remainder of the corpus, which if you look at the paragraph right above that, it says that the Boggy Creek property goes 2/3, 1/3. So if the language, the rest and the remainder of the corpus, wouldn't that mean, or the corpus, wouldn't that mean excluding the Boggy Creek property? The income there is to split 50-50?
So if you read Article D as a whole, which it actually includes 3 paragraphs, paragraph 1 tells us how to distribute the personal property. Paragraph 2 tells us how to distribute the Boggy Creek property. And paragraph 3 tells us how to distribute the rest of the trust assets and the income of the property. Paragraph 1 as to the personal property and paragraph 2 as the Boggy Creek property, neither of them mention any income. And it's because in paragraph 3, it tells us that the income is to be split 50-50 between the 2 beneficiaries.
So we read all these things together. Somebody wrote a book about reading. all these
Yes, you have to read all of,
things. Some Scalia guy and somebody wrote a book about that.
yes, you must read all of the provisions of the
That's just a
trust.
statute.
I've heard about.
That's
that.
just a statute.
I've
not
occasionally heard
trust.
about that.
He didn't delve into
Opinions
trust.
Nowadays.
All right, your time's up unless you have one final comment.
No, thank you.
All right. Oh, okay, good. Well, we don't have that on the six, so you don't have to write about Scalia. Okay, let's pick up there on the 2/3, 1/3. Your position is that she shouldn't have to pay any of this, and we get that. If she is to pay, your position is that the statute governs this and that it should be 2/3 to her and 1/3 because that property was right.
A specific devise, in effect, this specific devise, that's what the statute says, 738.201, it's clear. Now, a trust language could override that, but as I believe Judge Lambert pointed out, that the language here in the trust is actually fully consistent with that. So I think any other construction is very strained and just also, doesn't make sense, and why the basis of the statute, you leave property to this person or these persons, they should have the income from that. Others shouldn't participate in it.
I'm going to give you time to go back, and I just want to follow up a question that I asked your opposing counsel. On this cottage income, the gentleman that opined about the value, he said that you really couldn't rent that to anyone else.
Right, legally
It can't-
prohibited, I believe.
It can't be rented on its own. Opposing counsel said, well, she should have raised the rent to $12.50. It appears she was having to be getting anything for that.
Right.
Is it your position that she should only be assessed the $2,500 per month because anything they got from the cottage was a bonus?
I think that's makes perfect sense because that separate residence was not separately rentable. there was testimony, I think by the appraiser that, that was in violation of the zoning laws. And, it was just a situation, a family situation that was carried over and, Ms. Kersey, you know, that's what was her niece or her mother's niece, I forget which, her cousin, I guess, and she just continued that, you know, as a courtesy. It was,
So she
And,
should
you know,
raise the rent because she might chase the person off and then get sued by. the
yeah,
others for-
I think she testified she was trying to help her niece. And there was also testimony that the $700 included utility charge. There was only 1 meter on the property. It couldn't differentiate. She estimated at trial it was around 200 a month for that second residence. So I think that that should be reduced from the rent in terms of the amount.
But there was no breakdown given.
No,
It was
there
just-
was no-
It was just her estimate.
Yes,
She
There's
could
no way to
she could
break it
put
down.
something in writing if she wanted that to.
yes, sir, sure. Yeah, there's a lot done wrong here that could, in hindsight, could have been done better. Well, if I may just sum up my argument, going back to my primary argument that no rent is due. I was never argued that Ms. Kersey was a tenant in common and fee simple of this property. I want to quote a comment to section 6 of the restatement of trust. Third, that I set forth in my reply brief that sums up my argument perfectly and better, I think, than I can say. So it's talking about the interplay of statute of uses and the interest of beneficiaries in passive trust. And it says in jurisdictions and situations in which the statute of uses or counterpart legislation applies, the equitable interest of the beneficiaries of passive trust are converted to legal interest with the trustee's title extinguished by operation of law. For the most part, however, the substantive rights of beneficiaries and derivative rights of others do not depend on whether such a statute applies, because the beneficiary of a trust that has become passive or virtually so is essentially the owner of the trust property. That is my argument. That's the argument I made in trial court. That's the argument I make here. So, and I would just also stress in terms of a comment, response to what counsel said, is that general powers in a trust are just powers to give the trustee powers to do what the trust otherwise says the trustee is to do. The trustee cannot use general powers to override or thwart a clear directive in the trust. This trust said, distribute the Boggy Creek property. That's all we're talking about here. That's the subject of this entire litigation. Distribute it to my children outright, free of trust. I do not think the trustee could use whatever power was set forth in the trust to sell that property, to rent that property, to do anything with that property other than to preserve it until it was distributed to the beneficiaries. And in the meantime, as the comment says, even though distribution of the property is delayed, the beneficiary should be treated as if they were the owner, because that is the only way to afford them the rights they were given by the mother and implement her intent, which is, as the cases repeatedly, universally say, is the bedrock of trust interpretation, implementing within the bounds of the law what the grantor of the trust wanted, because it was her property. She has a right to determine how it's to be disposed of upon her death. And she said, give the Boggy Creek property to my children. Now, you can't reconcile that directive with a beneficiary who was given that property having to pay rent to the trust. It's just absolutely inconsistent.
Thank you. All right. Thank you very much for your arguments there. We've got about 10 minutes, we'll get 10:30. We'll take a recess, see if the parties are here.
In case anybody.
Yeah, in case somebody wants to YouTube in, yeah. Okay, we'll be in recess for,
Presiding, starting early.
yeah. Yeah.